the issuance by the pretrial chamber of a warrant of arrest. Pursuant Article 58(1)b of the statute, a chamber assesses whether the arrest of a person appears necessary. 1, to prevent a person from not appearing at trial. 2, to prevent a person from obstructing or endangering the investigation or the court proceedings. Or 3, where applicable, to prevent the person from continuing with the commission of that crime or a related crime which is within the jurisdiction of the court and which arises out of the same circumstances. In accordance with Article 60.2 of the statute, the person subjected to a warrant of arrest under Article 58 of the statute may apply for interim release pending trial. The pretrial chamber's ruling on such an application under Article 60.2 of the statute is provisional in nature, to the extent that it will be periodically reviewed at least every 120 days or at any time following a request by the detained person or the prosecutor, if satisfied that the circumstance so require. The pretrial chamber may modify its initial ruling on detention, pursuant Article 60.3 of the statute and Rule 118.2 of the Rules of Procedure and Evidence. Regarding the first ground of appeal and the question of whether the pretrial chamber erred in law by relying on hypothetical and non-specific risks to find that continued detention is warranted, the appeals chamber recalls that in determining whether the conditions pursuant Article 60.2 of the statute had been met, a chamber must find that detention appears necessary. In this context, the appeals chamber observes that a determination shall be made concerning the possibility and not the inevitability that one of the events listed in Article 58(1)b of the statute will occur, and that it is the responsibility of the relevant chamber to weigh the evidence before it pursuant to the relevant standard. The appeals chamber notes that in its assessment of risks under Article 58(1)b of the statute, the pretrial chamber relied on this legal standard. Indeed, the pretrial chamber correctly referred to the standard that the assessment under Article 58(1)b of the statute concerns the possibility, not the inevitability, of a future occurrence. It then analyzed the material before it against this standard. Accordingly, the defense has failed to demonstrate that the pretrial chamber misapprehended the legal standard relevant to the assessment of risks under Article 58(1)b of the statute. With regard to the pretrial chamber's assessment and weighing of evidence in assessing risks pursuant Article 58(1)b, subparagraph 2 of the statute, the appeals chamber notes that the pretrial chamber made reference to 5 documents, including media articles, publications of non-governmental organizations, and a book which, in its view, indicated that Mr. Duterte's inclination to interfere with investigation against him. In relation to the first document, a media article, the appeals chamber finds that it was not unreasonable for the pretrial chamber to rely on this document for its finding. Whilst this document does not mention Mr. Duterte himself as being directly involved in briefing individuals it does not refer to statements of close, it does refer to statements of close associates, including one where individuals would have been told to remain loyal. In any event, the Appeals Chamber observes that Mr. Duterte's alleged involvement in briefing individuals is but one of the factors that the pretrial chamber took into account to support its conclusions on Mr. Duterte's inclination to interfere with investigations against him. In relation to the other 4 documents, a book, 2 publications of non-governmental organizations, and a press article, the Appeals Chamber recalls that there does not exist in the applicable law of the court any impediment to use of newspapers, articles, or other public or open sources for the purposes of assessing the requirement under Article 58(1) of the statute. Nor is there any requirement that such material be corroborated. Noting this, the Appeals Chamber considers that it is possible to discern how the pretrial chamber reached its conclusion on Mr. Duterte's alleged involvement in the threatening and taking of retaliatory actions against individuals opposed to him. In any event, the Appeals Chamber observes that this is only one of the factors that the pretrial chamber took into account to support its conclusion on Mr. Duterte's inclination to interfere with investigations against him, and more generally on the risk of Mr. Duterte obstructing or endangering the investigations or the court proceedings. For these reasons, the Appeals Chamber considers that the defense has failed to demonstrate an error in the pretrial chamber's assessment and weighing of evidence before it in the context of its consideration of the risk under Article 58(1)(b), subparagraph 2 of the statute. In relation to the pretrial chamber's reliance on the notion of a network of supporters, the Appeals Chamber recalls that it has considered that it is sufficient for a chamber to establish that it is possible that a suspect had the necessary assets to abscond, and that there is a risk that a suspect has the financial means to abscond on the basis of concrete evidence. The Appeals Chamber has also held that the existence of a supportive network and financial means may be relevant to determining whether there is a risk that a person may evade justice or interfere with the investigation, and that access to the international contacts could provide the means to enable a suspect to abscond, whether or not there was evidence that the suspect would actually utilize such contacts. In the impugned decision, in determining whether Mr. Duterte posed a flight risk under Article 58(1)(b), subparagraph 1 of the statute, the pretrial chamber considered that he appears to have the necessary political contacts as well as to benefit from a network of support within the Philippines. The Appeals Chamber considers that contrary to the defense's argument, the pretrial chamber specifically outlined why it found that there existed a network of supporters in relation to Mr. Duterte, and for which reason this supported its conclusion that the risk under Article 58(1)(b), subparagraph 1 of the statute was established. In the view of the Appeals Chamber, the manner in which the pretrial chamber undertook this assessment was case-specific, as it took into account the specific circumstances of Mr. Duterte, amongst others, his position as former president of the Philippines and his recent re-election as mayor of Davao City in May 2025. It follows that the defense has failed to demonstrate that the pretrial chamber committed an error in assessing and considering Mr. Duterte's network of supporters for the purpose of its examination of the risk under Article 58(1)(b), subparagraph 1 of the statute. Further, under the first ground of appeal, the defense argues that the pretrial chamber's alleged reliance on irrelevant considerations led to errors of law and fact. Regarding the arguments on the assessment of evidence, and in particular, the defense's contention that a number of factors relied on by the pretrial chamber were irrelevant, the appeals chamber notes that when assessing the risk under Article 58(1)(b), subparagraph 1 of the statute, the pretrial chamber relied on several factors in support of its finding that such risk existed. It relied on a statement by Mr. Duterte, statements by others, Mr. Duterte's position as a former president of the Philippines and his recent re-election as mayor of Davao City, as well as the matter of the gravity of the alleged crimes and concomitant sentence in case of conviction. The appeals chamber observes that the defense does not explain why, in its view, these factors were irrelevant to the pretrial chamber's assessment. Without more, the defense has failed to substantiate that the pretrial chamber's reasoning and assessment were unreasonable. In the same vein, the defense fails to demonstrate that the pretrial chamber's reliance on Mr. Duterte's re-election as mayor of Davao City in its assessment of the risks under Article 58(1)(b), subparagraph 3 of the statute was unreasonable. Moreover, with regard to the defense's contention that the pretrial chamber selectively cited facts and ignored others in the same items of evidence, the appeals chamber considers that the defense has failed to demonstrate how the fact that the pretrial chamber accorded weight to the statement from Mr. Duterte that it cited should result in the pretrial chamber's ignoring or attaching no weight to other statements. Regarding gravity and concomitant sentences in case of conviction, it is recalled that the appeals chamber has consistently held that these factors are relevant considerations in assessing the risk under Article 58(1)(b), subparagraph 1 of the statute, as these are factors that may increase an incentive of a person to abscond. In the present instance, the gravity of the alleged crimes and the possibility of a lengthy sentence was but one of the factors the pretrial chamber took into account in its assessment of risks under Article 58(1)(b), subparagraph 1 and 2 of the statute. And it looked at the specific allegations against Mr. Duterte. It follows that the defense has failed to demonstrate an error. Regarding the question of whether the pretrial chamber erred in fact by failing to give appropriate weight to relevant facts, specifically Mr. Duterte's health condition and its mitigating effect on the risk factors set out in Article 58(1)(b) of the statute as argued by the defense. The Appeals Chamber recalls that there is no provision in the court's legal texts that specifically provides for the interim or conditional release of a detained person on health grounds. Nevertheless, the Appeals Chamber has indicated that the medical condition of a detained person may have an effect on the risks under Article 58(1)(b) of the statute, and may be a reason for a pretrial chamber to grant interim release with conditions. The Appeals Chamber considers that such a determination is necessarily case-specific. Contrary to the defense's assertion, nowhere did the pretrial chamber suggest that it was precluded from assessing the information about Mr. Duterte's health within the context of its assessment under Article 60.2 of the statute. Rather, it noted the reports placed before it and considered that they were unable to affect its finding on risks under Article 58(1)(b) of the statute. The defense has failed to show that the pretrial chamber's approach was unreasonable. For these reasons, having rejected the defense's argument under this ground of appeal, the first ground of appeal is rejected. Second ground of appeal. I will now turn to the second ground of appeal. Under this ground, the defense challenges the pretrial chamber's assessment of the proposed conditions of release and state warranties. The defense argues that the pretrial chamber erred in law in failing to address the proposed conditions of release and state warranties. The Appeals Chamber is of the view that the pretrial chamber did not appear to criticize a lack of detail in the proposed conditions, but rather in the details as how the state which accepted to receive Mr. Duterte would implement the necessary conditions. The pretrial chamber did not consider release with conditions as required, but found that in the circumstances before it, the risks it had identified could not be mitigated by the proposed conditions. Moreover, the Appeals Chamber is of the view that the pretrial chamber was not obliged, as suggested by the defense, to seek further observations from the concerned state, because it did not envisage the possibility of release given the risks it found Mr. Duterte presents under Article 58(1)(b) of the statute. For these reasons, the Appeals Chamber finds that the defense has failed to identify an error by the pretrial chamber when addressing the proposed conditions of release and state warranties. In relation to the question of whether the pretrial chamber erred in law by failing to consider if the proposed state warranties could mitigate the risks under Article 58(1)(b) of the statute, the Appeals Chamber finds that this does not appear from the impugned decision that the pretrial chamber would have required an elimination of risks, as argued by the defense. Instead, the impugned decision specifically states that the pretrial chamber did not consider the suggested conditions to sufficiently mitigate the identified risks. It is also apparent from the factors brought forward by the pretrial chamber when examining the implementation of conditions that it did consider them. Finally, the Appeals Chamber considers irrelevant to which conditions the prosecutor agreed when discussing potential release of the suspect to the host state. What matters are not conditions that may, in principle, be possible in case of a release to a state different to the one proposed by the defense. Rather, what is of consequence for the pretrial chamber's assessment are the conditions and warranties proffered in relation to a release to the state party concerned. For these reasons, the appeals chamber is of the view that the defense failed to substantiate the pretrial chamber's conclusions were unreasonable. Regarding the defense's contention that the pretrial chamber erred in fact and law by taking into account irrelevant considerations in respect to the state warranties, the appeals chamber considers that the pretrial chamber's finding mainly related to the implementation and enforcement of the proposed conditions. It considered the practical implications of ensuring adherence to the proposed proffered conditions in a situation such as the one at hand. It did so against the backdrop of having found that all three risks under Article 58(1)(b) of the statute were established. As such, it was reasonable for the pretrial chamber to examine how, in practice, the suggested conditions would be implemented. The defense has failed to show an error in this assessment. For these reasons, the appeals chamber considers that the defense has failed to show how the pretrial chamber erred in its assessment of the proposed conditions of release and state warranties. For the foregoing reasons, the second ground of appeal is rejected. Third ground of appeal. Regarding the third ground of appeal, within which the defense argues that the pretrial chamber erred in not considering humanitarian grounds either as independent consideration or mitigating factor in assessing interim release, the appeals chamber considers that the pretrial chamber did not refuse to address the question of interim release on humanitarian grounds. Rather, it gave the reasons for which, in its view, the humanitarian grounds advanced by the defense were not sufficiently set out in the case at hand. Further, the appeals chamber recalls that the medical condition of a detained person may be a reason for a chamber to grant interim release with conditions, and that the chamber enjoys discretion when deciding on conditional release. The appeals chamber considers that it is not apparent from the pretrial chamber's assessment that it was unreasonable. The pretrial chamber found the existence of risks under Article 58(1)(b) of the statute, which were not mitigated by Mr. Duterte's purported condition, and also could not be mitigated by any condition imposed upon release. The pretrial chamber then proceeded to analyze whether humanitarian grounds, as argued by the defense, could justify release on conditions. The appeals chamber thus considers that the pretrial chamber assessed the relevant information before it in light of the arguments made by the defense and reached its conclusion on this basis. It follows that the defense has failed to demonstrate that the pretrial chamber's assessment was unreasonable. Accordingly, the appeals chamber finds that the defense has failed to show that the pretrial chamber erred in its assessment. For these reasons, the third ground of appeal is rejected. finally, the Appeals Chamber notes that the pretrial chamber reached its conclusions in relation to the risks enumerated in Article 58(1)(b) of the statute on the basis of a comprehensive assessment of the information before it. In the present case, having rejected the 3 grounds of appeal presented by the defense in the appeal brief, the Appeals Chambers unanimously confirms the impugned decision. This brings us to the end of the summary of the Appeals Chamber's judgment. The judgment will be notified to the parties and participants after the hearing. Translations of the summary will also be available in due course. I would like to thank the court reporters, interpreters, and other registry staff for their valuable assistance today in holding this hearing. The hearing is adjourned.
All rise. We will